What is strategic litigation against torture? Strategic litigation seeks to challenge both the torture suffered by an individual and the policies and practices that enabled the torture to take place. Strategic litigation combines casework with other civil society techniques such as advocacy, public education, engaging the media, grassroots activism, and campaigning. Some names by which strategic litigation is also known are public interest litigation and test case litigation, but they all have the same objective: to bring about change beyond the case. Civil rights litigation was a key element of the movement in the United States from the 1950s, but the technique was first used by anti-slavery campaigners in the late 18th century who argued, "It is not what the law is, but what the law should be." What can strategic litigation achieve? Using this method, civil society organisations can obtain truth, justice, and reparations for both individuals and groups. The broader campaign can bring about systemic changes that increase accountability and prevent the use of torture in the future. It can also have an impact on other torture survivors in a similar situation, energise the anti-torture movement, and change the attitudes and practices of influential people such as judges, politicians, and journalists. It can influence the law and government policies and ultimately contribute to social change. Strategic litigation can be pursued through human rights litigation against governments, criminal cases brought against individuals, and civil cases asking for specific remedies. These cases can be brought in domestic courts, regional human rights courts, and the United Nations treaty bodies, including the Committee Against Torture. Strategic litigation against torture has been deployed all over the world. In Argentina, efforts by victims of the dirty war, civil society and litigators led to the adoption of a policy of memory, truth and justice, and the annulment of the amnesty laws. In Nepal, a campaign by survivors of torture and litigators led the Supreme Court to order the government to make a law to criminalise torture and enforce disappearances. Strategic litigation has been used to challenge torture in many different situations, including the torture of refugees and migrants, sexual violence, LGBT+ rights, and the torture of human rights defenders. Meriam was sentenced to death and lashing in Sudan for apostasy. REDRESS and partners helped Meriam bring a claim before the African Commission and advocated for legislative change in Sudan. In 2020, Sudan reformed its laws on apostasy. Azul is a transgender person who was raped while in detention in Peru. REDRESS and partners brought her case before the Inter-American Court, which ruled in her favour and ordered Peru to adopt wide-ranging measures to tackle torture and structural discrimination. But what are the risks? In many cases, these social advances may take years to happen. There is also a risk that the survivor's interests are sidelined when seeking broader change, and the survivor might feel disempowered or re-traumatized. Losing a case can also make a bad law become entrenched or worsen the situation of the survivor. Lawyers have an ethical duty to discuss the risks with their clients so they can make an informed decision as to whether to take a case forward. However, all of these risks can be mitigated through careful planning and professional engagement. They can also be mitigated by adopting a holistic approach. This means ensuring that survivors have a central role in the litigation and the strategy, receive proper medical, psychological, and social support, and are accompanied throughout the process. Visit redress.org/resources/training to learn more.